Have you ever watched a crime drama where the detective says, "We've got motive, means, and opportunity"? It sounds convincing, doesn't it? But here's the question. Is that actually the law? Do prosecutors have to prove motive, means, and opportunity before someone can be convicted? Or is it simply something detectives use while trying to solve a crime? The answer is surprisingly interesting. The phrase means, motive, and opportunity isn't a legal test in Ireland or in most other common law countries. Yet it is much more than just a catchy police slogan. In this video, we'll look at what each of these three concepts means, why investigators rely on them, and most importantly, what role they actually play in court. Let's begin with motive. Motive simply asks, why would someone commit this crime? Perhaps they stood to inherit money. Perhaps they wanted revenge. Perhaps they were jealous. Perhaps they feared being exposed. Those are all possible motives. Here's the important legal point. Motive is not normally something the prosecution has to prove. That surprises many people. Most people assume every crime must have a reason behind it. But the law recognizes something quite simple. People sometimes do terrible things for reasons that nobody else ever discovers. Sometimes they don't even understand their own reasons. So the prosecution doesn't have to explain why an accused person committed the offense. Equally, if the prosecution cannot identify a motive, that doesn't automatically help the defense. On the other hand, if there is evidence of motive, it may become valuable evidence. Imagine someone who inherits €2 million because a wealthy relative has died under suspicious circumstances. That doesn't prove murder, far from it. But if other evidence begins pointing towards that person, the financial motive becomes another piece of the overall picture. Think of motive like one piece of a jigsaw puzzle. By itself, it tells you very little, but alongside many other pieces, it may help reveal the whole image. That jigsaw puzzle is known as circumstantial evidence. The more pieces that the prosecution can add to the puzzle and show that they fit, so the clearer the picture becomes. Judges often remind juries that motive isn't something that must be proved. However, if there is evidence of motive, the jury is perfectly entitled to consider it together with all the other evidence. So motive has evidential value. It simply isn't conclusive. The second concept is means. Means asks a different question. Could this person actually have carried out the crime? We're talking about capability. For example, did they possess the weapon? Did they have access to poison? Did they have the specialist computer knowledge needed to carry out a cyber attack? Did they own the burglary tools? Were they physically capable of committing the offense? Again, notice something important. Having the means doesn't prove guilt. Thousands of people legally own knives. Many people possess specialist knowledge. Many people have access to chemicals. That doesn't make them criminals. Instead, means simply shows that someone had the practical ability to commit the offense. It's another piece of circumstantial evidence. Suppose investigators discover that a sophisticated cyber attack required very specialized expert programming knowledge. Only a handful of people possess that expertise. Immediately, the field of possible suspects becomes much smaller. That doesn't prove who committed the offense. It simply helps identify who could have done it. The third concept is opportunity. Opportunity asks perhaps the most practical question of all. Did this person actually have the chance to commit the offense? This is often where modern investigations become very evidence-driven. Opportunity may be shown by CCTV footage, mobile phone location data, DNA, electronic door entry records, travel records, employment records, eyewitness evidence. Sometimes opportunity becomes much more important than motive. Imagine someone who absolutely hates the victim. They've threatened them for years. They have every imaginable motive. But on the day of the murder in Ireland, they're on holiday in Australia. Clearly, they couldn't have committed the offence. No opportunity. Now imagine the opposite. Someone has no obvious reason whatsoever to harm the victim. But CCTV places them at the scene. Their DNA is found there. Their mobile phone records confirm they were present. Now opportunity becomes extremely significant. This illustrates an important point. People often overestimate motive. In reality, opportunity frequently carries much greater evidential weight. If they're not legal requirements, why do police investigators use them? Because they help organize an investigation. Investigators typically ask three simple questions. Who wanted this to happen? Who was capable of doing it? Who had the chance? When the answers to all three questions point towards the same individual, investigators know they've found someone who deserves closer examination. Notice what hasn't happened. Nobody has proved guilt. They've simply identified a suspect worth investigating further. So means, motive, and opportunity are really an investigative framework. They're a practical way of narrowing down possibilities. Nothing more, nothing less. Once the case reaches court, everything changes. The judge isn't asking, did the accused have motive? Did they have means? Did they have opportunity? Instead, the court asks one fundamental question. Has the prosecution proved every element of the offence beyond reasonable doubt? That's the legal test. The prosecution might rely upon direct evidence, forensic evidence, digital evidence, expert evidence, admissions, or circumstantial evidence. Means, motive, and opportunity are simply categories into which some of that evidence may fall. They're not legal ingredients of the offence. They're not boxes that have to be ticked. Let's imagine a poisoning case. The accused stands to inherit €2 million as his rich uncle has died. That's motive. The accused bought cyanide the week before. That's means. The accused was alone with the victim shortly before death. That's opportunity. None of those facts proves murder. Each fact is perfectly capable of having an innocent explanation. But taken together, they begin forming a compelling circumstantial case. Now compare that with a completely different situation. Someone is caught on multiple CCTV cameras stabbing another person under a very bright streetlight. There may be no known motive, no discussion of means, no argument about opportunity. The direct evidence alone may establish guilt beyond reasonable doubt. Conversely, someone may possess all three. They may have motive, means, opportunity, yet still be completely innocent. That's why the law never treats these three ideas as proof of guilt. So what should we remember? Means, motive, and opportunity are not legal requirements. The prosecution does not have to prove them. Equally, the absence of one or even all three doesn't automatically prevent a conviction. Instead, they are best understood as three common forms of circumstantial evidence. Each may strengthen a case. None proves guilt on its own. Ultimately, every criminal trial comes back to one simple question. Has the prosecution proved the accused's guilt beyond reasonable doubt? Everything else, including means, motive, and opportunity, is simply part of the evidence the court considers when answering that question. I'm Neil, and you have been watching The Law is My Oyster. Until next time, ahdios.
Lit the fire where the dark intentions grew, placed every instrument within the suspect's view. Opportunity arrived when no one else was there. 3 silent threads entwining in a deadly hidden snare. Yet motive proves no action, and means alone won't do. Opportunity is powerless without convincing proof. The truth is built on evidence, not what appearances imply. For guilt is proved in court, not by suspicion's watchful eye.